Well, thank you, Mr. Speaker, and I want to thank the member for Okanagan-Shuswap for bringing this bill forward. As he mentioned, this was a bill that I introduced in the first session of this Parliament, and because of my appointment as Parliamentary Secretary, my bill had to be withdrawn, although it did make it to committee. So I would hope that members will expedite this process so we can get this to committee and where it was a year ago. You know, sitting here and listening, especially to the Liberal banter right now, really was disappointing. And not one point did he mention the victim. Not once. And it comes back to this whole ideology of the Liberals about hugging the thug, about trying to protect the criminal rather than protecting Canadians and those victims. You know, the title of this bill is Respecting Families of Murdered and Brutalized Persons Act. And it is work that I started some time ago, and I'm very happy that my friend from Okanagan-Shuswap has taken on this task here in the House to ensure that families don't have to go through unnecessary parole board hearings and be re-victimized time and time again. So let's make sure we have our hearts in the right place, our hearts with those families that have already lost their loved ones and now have to relive that horror of the most heinous criminals out there that have not only gone and murdered their child or family member, but they abducted them and they sexually assaulted them. Now, this bill goes back to amending Section 745 of the Criminal Code. And I have to stress that Bill C-587 is about empowering our courts with the ability to increase parole ineligibility when sentencing individuals who have abducted, sexually assaulted, and killed our innocent and often most vulnerable Canadians from the current 25 years up to a maximum of 40 years. It's at the discretion of the courts. They make the decision on whether or not they take it up any higher. Now, this bill is not about creating stiffer penalties for these sadistic murderers. These deprived and depraved convicts don't qualify for parole. And, you know, we've already mentioned that. The worst case scenarios that we have in the prison, you know, these half-dozen individuals that have been alluded to, never make parole. They never ever get out of jail. And so the reality is the families still have to go every 2 years, starting at year 23, and hearing the tragedy of their child or loved one being abducted, kidnapped, raped, sometimes tortured, and then murdered. And we want to put an end to that. So this bill is about saving the families of the victims from having to go through this agony of attending these unnecessary and traumatic experiences at the parole board hearings. Now, again, we said this is not about mandatory minimums. This, again, is about empowering our judges and the juries on making decisions and coming to a reasonable decision on the penalty of parole ineligibility. Now, let's talk about, is this constitutional? Does it comply with the Charter? Well, I can say the fundamental principle of sentencing is that a sentence must be proportionate to the gravity of the offense and the degree of responsibility of the offender. Now, the seriousness of the offenses set out in this bill will ensure that parole and eligibility period will only be applied in cases where the murderer's moral blameworthiness is very high. Again, abduction, sexual assault, and murder, all three. So this, again, allows for judicial discretion and ensures Charter compliance because it's not mandatory minimums. Now this goes back to Bill C-48. We use the same principle, protecting Canadians by ending sentence discounts by Multiple Murderers Act. And it's important to note that the NDP supported that bill back in 2011. And that in itself, I think, is noteworthy, that if it was okay to support it in Bill C-48 back in 2011, I would hope that the NDP would support that same principle when it applies to these most heinous criminals. Now, Jim Malloway, who was the NDP member at that time from Elmwood Transcona, said, "Mr. Speaker, I'm pleased to speak to what is now Bill C-48. I essentially support the bill, which our critic, the member from Windsor, Tecumseh, has already indicated that our party supports. In fact, all opposition parties support the bill. I guess one of the good things about the bill is that it does leave discretion to the judge, which the opposition members have been consistent in supporting in the past. Perhaps the government recognized that by allowing the judge discretion, it made it certain that the bill would actually go somewhere in the House." End quote, Mr. Speaker. Now, the compliance section that we're concerned about is Section 12 of the Charter, and by going the route that is presented in Bill 587, providing that judicial discretion makes it charter compliance, because that is key. Now, as we were saying, this is about the most heinous and most horrendous individuals that we have in Canada. We're talking about Robert Pickton, Paul Bernardo, Russell Williams, Michael Rafferty, Terry Lynn McClintock, Clifford Olson, Donald Armstrong, James Dobson, David Shearing, and just recently Luca Magnotta. So these individuals are repulsive in our society. They have committed the most tragic criminal acts on an individual that people could ever imagine, and yet there's an argument coming forward that they should only have to sit there for 25 years. And we know that they sit there longer because they never actually ever make parole eligibility. They're never ever put out back into society. You know, in the sentencing of David Theron back in 1975, Justice Hughes, who was a judge at the time, stated, he says, in reference to David Theron, he said, "Never again should he be on the streets and roadways of our country." The judges already see how repulsive and dangerous these offenders are, and they need to make sure that they are never released back into the society. You know, you look at Robert Pickton, unfortunately, multiple murder, you know, we're talking 25 counts, but only second-degree murder charge. So that means 10 years. In 10 years, he can start coming now and receiving his parole board hearings. And he'll probably never ever get released, but that means that 25 families are going to be reading victim impact statements at parole board hearings every 2 years in a matter of a couple of years from now. That is sickening. Now, I tell you, one of the reasons, Mr. Speaker, that I got thinking about this case is a few years ago I was riding around in my riding and listening to the Tory Stafford case about the little girl that was abducted, raped, and murdered. And it just broke my heart. And, you know, it involved Michael Rafferty and Terry Lynn McClintock. And, you know, they brutally, after they stole her from school and they sexually assaulted her, they killed her with a hammer. And, you know, Terry Lynn McClintock got a life sentence in 2010. You know, Michael Rafferty got his life sentence. You know, Tory Stafford's family shouldn't have to go through in 25 years having to start reliving that murder, that abduction, and that sexual assault every 2 years from there on in. You know, we talk about Russell Williams, you know, murdered, abducted, raped, and murdered Jessica Lloyd and Marie France Comeau. We talk about Clifford Olson, and you know, Sharon Rosenfeld, I have to thank. I you know, really got involved with her and her organization, Victims of Violence. She supported this bill right from the beginning. Her son Darren was murdered, and my friend had already talked about how Darren was killed and how they were re-traumatized. You know, I also have to thank Susan Ashley, who also provided me support and ideas for this bill, and Yvonne Harvey from the Canadian Parents of Murdered Children for their work on this bill as well, and making sure that Canadians are aware that this was coming forward. And finally, I want to thank Senator Beausoleil, who founded the organization Murdered or Missing Persons Families Association, and because of his own personal loss and also his support and making sure that this bill will go forward in the Senate side. So, Mr. Speaker, I just again ask that members of this House support this bill, get it to committee so it can be given the proper study. Thank you very much.